Welcome to This Explainer. Today, we're unpacking the high-stakes, genuinely fascinating mechanics of international shipping disputes. We're going to use the source material on Admiralty and Maritime Law to understand exactly how nations manage to maintain order out on the open ocean. It's so easy to forget, but this legal framework is the invisible backbone of the global supply chain, the rules that actually bring goods right to your front door. Shipping is, without a doubt, the ultimate international industry. You've got this incredibly complex web of ship owners, financiers, cargo owners, ports, and crews all coming from completely different corners of the globe. And well, with that many moving parts, disputes aren't just likely, they're absolutely inevitable. So let's just dive right into the massive inherent problem of global shipping. Imagine a foreign ship causes severe damage in your local port, or maybe they just flat out fail to deliver your cargo. How on earth do you hold them accountable when the owner is sitting safely in a completely different country? They might not even have a registered business in your jurisdiction. It is quite literally a massive logistical and legal headache. To figure out how we solve that, we're going to follow a pretty clear roadmap today. We'll look at resolving high seas disputes, the origins of Admiralty Law, how it evolved in Indian courts, defining legitimate claims, and finally the actual mechanics of a ship arrest. Let's kick things off with Section 1, Resolving High Seas Disputes, and the core distinction in maritime law. We need to start with the absolute legal magic trick that makes maritime accountability possible in the first place. Think about a normal civil lawsuit. Usually you sue a person or a specific company, right? That's what we call a proceeding in personam. But in maritime disputes, as we just established, the owner might be completely unreachable. So Admiralty Law steps in with something wild. It allows you to proceed in rem. This means you actually have the right to proceed directly against the physical ship itself or its cargo. You are essentially bringing a lawsuit against a massive steel vessel as if it were a legal entity. It's truly the most effective way to enforce claims globally. And this brings us to a brilliant point made by Justice Tommen, which perfectly captures why arresting a vessel in territorial waters is such a big deal. It's not just about recovering a financial debt. It's about the judicial sovereignty of a state. Think about it. If a country couldn't enforce claims against foreign ships operating right there in its own waters, it wouldn't truly be a sovereign nation. The power to arrest and detain these vessels is exactly what gives maritime law its teeth. Moving on to Section 2, Origins of Admiralty Law, from Custom to Royal Courts. So how did this incredibly unique legal power actually evolve from ancient seafaring practices all the way to formalized British law? Well, maritime law actually grew organically out of the practice of sea transportation itself, which is pretty much as old as human civilization. But the specific Admiralty Law framework we recognize today, that was largely forged in England. Being an island nation, almost all of their commerce relied on the sea. Now, before they had formal statutes, disputes were settled by these historical figures known as the Lord High Admirals, along with their deputies. They acted as the ultimate maritime authorities, and they didn't rely on strict written law at first. Instead, they decided cases based purely on equity, deep-rooted maritime custom, and standard trade usage. But it definitely wasn't smooth sailing. There was this intense, centuries-long tug-of-war with the standard common law courts. See, admiralty courts also handled criminal matters at sea, which created a massive rivalry. In 1389, the British Parliament stepped in and severely limited admiralty courts to disputes occurring exclusively upon the sea. But, as global trade absolutely exploded, the law had to adapt. By 1840, the Admiralty Court Act extended their reach back inland to handle domestic cases and ship damage. And this consolidation just kept going through 1925 and again in 1956 and 1981, constantly broadening the court's jurisdiction to match modern international conventions. Which brings us to Section 3, Evolution in Indian Courts, Inheriting and Challenging Colonial Law. Let's look at how this British framework translates to India, where admiralty jurisprudence was introduced directly by the British alongside common law. It started early on with the mayor's courts of the East India Company, which eventually gave way to a much more formalized system. The major turning point happened when the British Parliament passed the Colonial Courts of Admiralty Act in 1890, followed by the 1891 Indian Act. This officially declared the high courts at Calcutta, Bombay, and Madras as colonial courts of admiralty. This meant they were suddenly granted the exact same unlimited jurisdiction as the high court in England had at that time. And interestingly, because independent India didn't immediately pass a brand new Admiralty Act, these courts actually retained those specific colonial powers via Article 372 of the Indian Constitution. But, as you can imagine, relying on 19th century British law eventually caused a massive problem. The Old English 1861 Act had a really strange quirk. It actually restricted actions regarding outward cargo. And this specific restriction sparked a monumental legal showdown in what's known as the M.V. Elizabeth case. Basically, a Goa-based plaintiff sued a foreign ship for breaching its duty. The ship had left Port of Marmagoa without issuing a bill of lading and ended up misdelivering the cargo. But the defendant company fought back hard. They argued that since they were a foreign company with no office in India and the issue was about outward cargo, the Andhra Pradesh High Court had zero jurisdiction to arrest their ship in an in-rim action. This is where the Supreme Court of India stepped in and delivered an absolute landmark ruling. First off, they confirmed that Andhra Pradesh did have jurisdiction as a successor to the Madras High Court. But the real bombshell was their core ruling. They declared that Indian high courts are now uninhibited by the limitation of the power of the High Court in England under the 1861 Act. With that one decision, they firmly broke India free from those outdated British colonial restrictions, completely modernizing the court's ability to hold foreign ships accountable. All right, into Section 4, defining legitimate maritime claims, or when can you actually invoke admiralty law? We know the courts have the jurisdiction now, but what exact claims allow them to take such drastic action against a ship? The source material lays out 14 very specific statutory claims, and they basically fall into three major buckets. First, you've got claims for physical damage, loss of life, or lost cargo. Second are the essential services that actually keep ships moving, things like salvage operations, towage, and supplying materials for operation. And the third bucket covers ownership disputes, mortgages, and, super importantly, unpaid crew wages. Essentially, if your dispute falls into one of these core categories, you are good to invoke admiralty law. And that brings us to Section 5, honestly the most dramatic part of this explainer, the mechanics of ship arrest. How exactly do you physically stop a massive ocean-going cargo ship from just pulling up its anchor and sailing away to avoid paying its debts? Well, an admiralty action doesn't mess around. It literally begins with a strike. It's a remarkably effective four-step process. Step 1, the claimant files an application. Step 2, bam, the court issues a warrant of arrest, directing port authorities to physically prevent the vessel from leaving. The ship is officially trapped. Now, in Step 3, the owner faces a serious choice. They have to deposit an adequate security fund or a bank guarantee to cover the claims. If they cough up the security, the ship is allowed to sail. But Step 4 is the hammer. If they fail to put up that security, the court will absolutely sell the vessel at auction to realize the funds and pay off those claims. No exceptions. Now, let's say the ship gets sold. The resulting pile of money isn't just handed out any free-for-all. There is a very strict hierarchy, governed by international conventions. For example, salvage claims almost always jump right to the very front of the line. And if you think about it, the reason why makes total sense. Without those brave crews who performed the salvage operation to save a sinking or stranded ship, there literally wouldn't be a ship left to sell. They saved the asset, so they get paid first, ensuring the property is actually there for everyone else to get their dues. But wait, what happens if the guilty ship has already escaped your territorial waters before you could even get the warrant issued? Maritime law offers this incredible wild card, known as the sister ship arrest. If the exact same owner beneficially owns a totally different vessel, and that second vessel happens to sail into your port, you can just arrest that ship instead. It's a brilliant mechanism that ensures fleet owners can't just dodge their liabilities by shuffling their ships around the globe. We've really seen how this legal framework evolved, from ancient seafaring customs all the way to incredibly powerful modern statutes. So I want to leave you with this final thought to chew on. In an increasingly borderless world of global trade, without these formidable maritime laws and the sheer physical leverage of a ship arrest, how could any nation possibly protect its ports, its businesses, or its people from the fleeting giants of the sea? It really is the ultimate expression of sovereignty, isn't it? Thanks so much for joining me for this explainer, and remember to keep questioning how the complex world around us actually works.